3 days ago, a recent grad from the prestigious St. Paul's School in New Hampshire, 19 years old, who had been preparing to head off to Harvard, learned instead he could be heading to prison for quite a while. Well, a jury found Owen Labrie not guilty of felony sexual assault of a then 15-year-old freshman at the school. They did find him guilty of 4 misdemeanor charges of having sex with an underage girl and a felony charge of using a computer to lure a minor. In the end, he could be sent away for as much as a decade, and he'll be required to register as a sex offender for life. Earlier, Labrie reportedly had turned down a plea deal that would have meant no sex offender registration. And he went through a few lawyers over the course of his case. His final one, J.W. Carney of Whitey Bulger fame. Jay joins me now. We also invited the prosecutors to join us this evening. We did not get a response. Jay, thanks so much for being here. Appreciate it. It seems to me from afar the jury split the baby. I know you're unhappy with the felony conviction. We'll get to that in a minute. But isn't it fair to say that justice was served in one of these he said, she said cases?
I don't think it was splitting the baby and reaching a compromise. I think the evidence was overwhelming that if these two kids had gotten together, everything was totally consensual. And the jury's final verdict was basically 2 kids, teenagers at the same high school, had consensual sexual activities with each other.
But your guy was denying that he had even had sexual intercourse with her. The jury seems to be saying, not seems to be saying, with the misdemeanor convictions, he wasn't telling the truth about sexual intercourse, and the state didn't make a good enough case that it was not consensual. That's a fair description of what happened, isn't it?
It is. And I think that the statements made by my client in the day or two after the encounter were the most damaging evidence against him.
I mean, to his friends.
He said to his friends, when they would ask him, hey, did you score? He said, yep, I scored. Or did you slay the complainant? Yes, I did. And he was being boastful with them because it made him look better rather than telling the truth.
Yeah, but those words, getting to that was, he says, I lied to them essentially because it made me look good. Couldn't a jury conclude that he lied to them as well in the other direction to make him look good in their eyes? If he lied earlier, why would he not be lying here when the stakes arguably are a hell of a lot higher?
I think the most significant response to that is the fact that he turned down a plea to a misdemeanor that would not involve registration for life as a sex offender. Someone has to be truly believing in his own innocence and saying, it's more important to me that I tell the actual truth than take a deal that I'll regret the rest of my life.
Were you his lawyer at that time?
No.
That was this New Hampshire attorney, is that correct?
Yes.
Would you have advised him to have taken that plea?
I don't advise clients about what to do. I try to help them make the right decision. I go over the pros and cons, the likelihood of success, and then help them make the right decision for them, because every defendant would answer the question in a different way.
Can we talk about this felony for a minute? I know this is the one you're most upset about, not only because it carries the longest potential term, I think up to 7 years, sex offender registration for life. The thing I don't understand about the law, and I hope you'll straighten me out, New Hampshire law is that if you have sexual intercourse with a minor and there's a 4-year differential or less, it's a misdemeanor.
That's correct.
But if you lure a minor through a computer to have sex, that's a felony?
Yes, and I think it's...
How do they rationalize that distinction? Well, I get maybe that's your argument.
The statute, in my opinion, never was intended to apply to this situation. Law enforcement was having trouble with predators, maybe a 40-year-old guy who'd get online and pretend to be a 15-year-old boy, try to get a 15-year-old girl to send them nude pictures of herself or meet him out behind the mall. The only way they could prosecute that person once he's committing that conduct is this type of statute. And because that type of predator would be so dangerous, you would expect him to be registering for life.
And that's your case on appeal in this thing. That's essentially what you're going to argue, yes?
I'm going to bring a motion asking the trial judge to vacate the conviction.
You know, how did your, we all saw the video of your client putting his head in his hand, weeping, that sort of thing. Was that with relief or what was it? I mean, obviously he faced much more serious charges, and I assume that you say you didn't split the baby. I think most outsiders feel that way. What was his reaction to this?
He was devastated. The fact that the jury had rejected what he testified to was the truth just hurt him to his core, and that's why he was sobbing.
You are probably as experienced and as respected a defense lawyer as there is in this town. You're also a father. How hard is it to do the kind of cross-examination that you chose to do of the now 16-year-old, then 15-year-old?
it's what you have to do to put the truth forward. She made such a dramatic presentation in terms of turning on and off the tears, yelling at me, but it really was the moment where I thought she had lied intentionally
About what?
to the jury. Her roommate was going to be testifying at the trial that the complainant had told her before she was meeting with my client that she was intending to engage in two types of sexual activity, including oral sex on my client. Well, during the trial, her backstory that she presented to the jury is she was totally inexperienced in sex, never had any dealings with a boy about this, and that's why this was just so traumatizing for her. Well, I know we're not a family program, but when you say to your roommate, your close friend who testified to this, oh, I'm probably going to let him finger me and I'm probably going to blow him. That's not the statement of a novice.
But when she said, I was raped, I was violated in so many ways, the jury bought that.
No, they didn't.
What do you mean?
They rejected it. If they had believed that account, Owen would have been convicted of forcible rape.
Jay Carney, what's your advice to schools like this? What should they be doing to make it less likely that there are ever circumstances like what happened between your client and this young woman?
I think the genesis of this whole tragedy that made both the complainant and my client victims is a so-called tradition at St. Paul's School. The tradition was called Senior Salute. Everybody knew about it. Every witness who testified said they were aware of Senior Salute, which was a senior boy asks a freshman girl to get together on the eve of his graduation. That's a recipe for mischief at best and disaster at worst. The fact that the school would continue to accept this was horrendous.
Well, even though they said they didn't know about it until a couple of years ago, you're not buying that.
Oh, please.
We only have 15 seconds left. Sentencing is when, in October?
October 29th.
Are you going to be asking for no jail time for probation for your client?
Yes.
Based on what, quickly?
I'm going to ask for probation given his lack of prior record and the fact that these are two teenagers who consensually decided to have sexual activity with each other. That does not deserve a prison sentence, especially when my client has lost so much in his life and will be branded with this conviction.
Well, she's
forever.
lost a lot too, Jay Carney. Would you not agree?
Yes, I would. And I say that as the father of a boy and the father of a girl.
Jay, thank you so much.
Okay,
Good to
Jim,
see you.
good to
Jay
see
Carney,
you.
I appreciate it.